welcome to Northwest Now. I'm Jill McCartney with the Northwest Oklahoma City Chamber, and we are here today with Kris Steele, who is a former speaker of the Oklahoma House of Representatives, but of late he is working with a team and is one of the state's biggest advocates for criminal justice reform. Hi, Kris. How are you today?
I am well, Jill. How are you?
Great. Well, how did you first get involved with this criminal justice effort? Tell me a little bit more.
You bet. Well, first of all, thank you so much for the opportunity to have this conversation and discuss what I consider to be a very important issue. Very quickly, my introduction and interest in criminal justice reform actually came about during my time of service in the state legislature. So I had the opportunity to serve in the state house from 2000 to 2012. And along about 2008, I was given some additional responsibility over our state budget. And the thing that jumped off the page for me at that moment in time is that in 2008, spending for incarceration had become Oklahoma's second fastest growing expenditure. And I can tell you that in every discussion, every debate, every decision that I participated in, up until that point, when in reference to corrections policy or corrections spending, the goal was to reduce crime, and then realized just how much the state of Oklahoma was spending annually to incarcerate people. And when I realized that we had literally the highest incarceration rate per capita of any state in the nation, I initially thought to myself, well, this must mean that we have some of the lowest crime rates as well, because that's why we were doing what we were doing. And much to my surprise, it was very perplexing. I realized that even though we had the highest incarceration rate, even though that spending for incarceration was our second fastest growing expenditure, our crime rate, our state's crime rate in Oklahoma was much higher than the crime rate of about 38 other states who had a much lower incarceration rate. It was much higher than all the states that are contiguous to us. And it really led me to try to discover what was happening. And in the process of doing my homework and visiting other states and learning more about policy and criminal justice systems that actually reduce crime and actually have the intended effect, I realized that what we're doing here in Oklahoma is just simply not working. We're painting with a very broad brush, and not only do we incarcerate more people and look at incarceration as a solution for a whole bunch of crimes and nearly all crimes, we also incarcerate people in our state for much longer than other states, particularly when it comes to nonviolent offenders. And so the reality is this: individuals convicted of nonviolent offenses in Oklahoma tend to spend about 75% longer in prison in our state than they would for the very same offense in any other state. And the reality is that these excessive sentences, these extremely long sentences for nonviolent offenders, were an improvement in public safety, but it is costing the taxpayers of Oklahoma a fortune. It's putting a very harsh strain on families, and it's leading to a number of social ills. So very quickly in the course of time, I've also realized that Oklahoma statistically also has the highest number of grandparents raising grandchildren per capita. And every single study that I've researched to look at the driving factors behind the number of grandparents raising grandchildren, the issue is mass incarceration. We also have one of the highest adverse childhood experience score collectively of any state in the nation. And again, if you look at what's driving that, it's this issue of mass incarceration. Oklahoma's foster care system is currently under a federal lawsuit because the federal government intervened in 2012 and said that we aren't providing adequate services for the number of kiddos in foster care. The number of kids in foster care in Oklahoma is directly related to this issue of mass incarceration. And so ultimately, as we begin to understand that the policies that we've created and the system that is currently in place is not producing the intended results that we want, and as we look at what is working in other states, we now have evidence that we can base our policy ideas on to actually safely reduce our prison population, strengthen families and make better use of our state's resources.
You have been involved with a lot of efforts, and that what have been some of the good things that have been happening so far over the last couple of years?
Sure. So the reality is, in 2016, the voters of Oklahoma passed a couple of state questions known as State Question 780 and 781. What that did is it reclassified simple drug possession for individuals who battle addiction from a felony conviction punishable by incarceration to a misdemeanor. And the idea is to connect individuals who need help with treatment. It really signified a significant shift in our thinking and realizing that addiction is a disease, it's a health issue, and that people who battle addiction really ought to be treated as patients, not as prisoners. The other thing that it did is it raised the property threshold for grand larceny from $500 to $1,000. And since the reforms went into effect, we've seen tremendous improvement, not only in a modest reduction in our overall prison population. The reforms themselves since 2017 have resulted in about a 9% reduction in our overall prison population. And that's reason to celebrate until you consider that in 2016, when we started, Oklahoma's prison population stood at 112% capacity. So reducing it by 9% is great efforts, but it's not nearly enough. We still have the overall highest incarceration rate to go. We have the highest overall incarceration rate of any state in the nation. The report indicated that we are still currently incarcerating women at nearly 3 times the national average per capita. And so we know that reforms work, because not only have we seen a modest reduction in our prison population, we've also seen a reduction in our crime rate. So property crime is down, drug-related arrests are down, and most importantly, drug-related overdose deaths are down about 22% since 2017 in Oklahoma. That's fantastic, and it gives us the proof that we need to know that responsible, evidence-based policy solutions actually work in Oklahoma, just like they do in all the other states that have already enacted them. And so we're seeing some progress enough to know that what we're doing is working and that we're on the right track, but we have a lot of work yet to do.
State Question 805, what is that proposing to do, and why is it needed?
Yeah, so thank you so much for the question. So State Question 805 is the next logical step in safely reducing Oklahoma's prison population, strengthening families, and making better use of our state's resources. What State Question 805 seeks to do is limit the use of what's called sentence enhancements for nonviolent offenses. So sentence enhancements would be the practice of adding additional time in prison beyond the maximum range of punishment for anyone who has a prior nonviolent conviction anywhere in their record. And so State Question 805 is not a free pass. People who are convicted of felony convictions today will still be convicted of felony convictions under 805. They will still go to prison up to the maximum range of punishment for that offense. They just wouldn't have additional years or decades tacked on beyond the maximum range because they have a prior conviction in their background. State Question 805 does not apply to anyone who is convicted of a violent offense or a sex offense. And Jill, just very quickly, by way of historical perspective, sentence enhancements, this very practice that we are referring to actually came into being in Oklahoma in 1999. It was the response to a situation that happened in California, not in Oklahoma, but in California, the very horrific and violent situation. And the way that California responded to that situation in 1998 was by creating the 3 strikes and you're out rule, but they only applied it to individuals convicted of violent offenses. That initiative, that 3 strikes and you're out policy, was incredibly popular, politically popular, and virtually every state in the nation adopted some variation of that policy. Well, in 1999, Oklahoma adopted a variation of the 3 strikes and you're out rule, but they applied it to every single felony conviction in statute. We didn't apply it just to individuals who commit violent offenses. We applied it to everyone. And then we went a step beyond that and said, let's not just have a 3 strikes and you're out rule. Let's have a 2 strikes and you're out rule. And so what has happened in Oklahoma is for anybody who ultimately is convicted for a second nonviolent offense, they literally are subject to life in prison. They are subject to the same sentence that somebody who commits murder is subject to, and it just doesn't make any sense. And so the reality is we have a prison system full of people who have committed nonviolent offenses. It's not making us any safer, and the research is pretty clear that when a person convicted of a nonviolent offense spends excessive time in prison, they tend to pick up additional antisocial behavior. It doesn't lead to a better outcome. In most of the cases, it leads to a worse outcome. And so the reality is that State Question 805 limits the practice of sentence enhancements only for nonviolent offenses, brings us in line with about 48 other states in applying the 3 strikes and you're out rule to violent offenders, and allows us to save money. In fact, when State Question 805 is passed, according to the analysis, it will save nearly $200 million to the taxpayers of Oklahoma. That's $200 million that can be reinvested in education, in infrastructure, in mental health care, in treatment services, in issues that actually improve the quality of life within our state. This is a responsible, modest, well thought out, well planned, evidence-based reform that's good for the state of Oklahoma.
Having been in the legislature, I know that you're very familiar with when legislation passes and is put into action. After it is enacted, turns out that there are some unintended consequences or some loopholes or some other problems with that, and they have to come in and do a cleanup bill the following year or sometime after the problem becomes evident. The problem with this is it's not statutory. It would be in the state constitution, and we would be unable to change that. Do you see any problem with that? I mean, that's something why is it being a constitutional amendment and not something that was pursued and passed through the legislature so that if there were any problems, it could be corrected?
Yeah. So first of all, I don't think that that's a problem at all. I think that that's really a good thing. And I'll just tell you that amending the Constitution when it comes to criminal justice issues is common practice in Oklahoma. So let me just start in 2011 when the people, by a vote, amended the state constitution to remove the governor from the pardon and parole process for nonviolent offenders. 2 years ago, in 2018, the legislature passed an initiative and sent it to a vote of the people to amend the state constitution to protect the rights of victims. The initiative was called Marcy's Law. It was a constitutional amendment that the legislature demanded. Governor Keating, when he was in office, amended the state constitution when Oklahoma became a right-to-work state and insisted that our constitution be amended for that policy change. This is common practice. I will tell you that the reason that the constitutional amendments exist is because it protects the will of the people. It protects the vote of the people. And to your point, what we've seen time and again is that when the people of Oklahoma decide on a certain issue, there are attempts by the legislature to repeal or to undermine or to take away and diminish the will of the people, the vote of the people. A constitutional amendment protects the vote of the people, and that's very, very important. That being said, there are all the safeguards in place so that the legislature can maintain the authority to establish the range of prison time for any felony conviction, both nonviolent and violent. So when 805 passes, if the legislature decides that a given range of punishment, prison time, is not appropriate for any offense, they have the authority. They have the discretion to modify that range of punishment. It's a safeguard that was built into place so that the legislature would maintain control of what the actual prison sentences are. But Jill, what State Question 805 does is it limits disproportionate sentences. It makes no sense that a person from one area in Oklahoma who's committed a given offense receives 45 years in prison, and a person in another place in Oklahoma who commits the exact same offense only spends 5 years in prison. So what does it establishes the range of punishment, the range that the legislature ultimately has control over, but it's a range that every Oklahoman, regardless of the geographic location that you're from, regardless of how much money you have in your bank account, regardless of the color of your skin, every Oklahoma would abide by. It creates a standard range of sentencing that everybody would adhere to. That creates a more fair and just system. But the safeguard is this: if the legislature determines that any of those ranges are not sufficient, they have the authority to go back and modify the range. That is provided in State Question 805. So this gives the people of Oklahoma the ability to give directives to say, hey, we don't want to spend all of our money incarcerating individuals convicted of low-level nonviolent offenses, but legislature, if you see that there's an offense that the sentence needs to be adjusted, you can do that. That's the safeguard that exists in State Question 805.
And as you've described what can be vast variances between length of sentences depending on where it is, what is the reason for that variance right now?
So right now, because of sentence enhancements, in the case of a second offense, the range of punishment is up to life. Mm-hmm. That's why that discretion exists. That's why there's such a broad discretion. There will still be discretion for prosecutors and judges to take a person's previous conduct into account, but for nonviolent offenses, it has to stay within the range of sentence. So, Jill, I would just say that a normal range of sentence for nonviolent offenses would be like 2 to 7 years or 0 to 10 years. Those are very common ranges of punishment for nonviolent offenses in Oklahoma. And so a judge would maintain the discretion to sentence a person to prison anywhere within that range. It could be, if it's a first-time offense, we would hope and expect that it would be on the lower end of the range, maybe 1 to 2 years. If it's a second or third offense, we would expect it would be in the middle range. And if it's a fourth or beyond, we would expect that it would be at the maximum range. So there's still that discretion that is provided for. In addition to that, the other safeguard that remains in place under State Question 805 is that prosecutors maintain the decision to charge the offense either as nonviolent or as its violent counterpart. So for every offense, nearly every offense, there is a violent counterpart. So an example would be domestic violence. Domestic violence, under State Question 805, anyone convicted of domestic violence would go to prison for 10 years. 10 years. They would be subject to 2 separate reviews by the Pardon and Parole Board and a 3rd independent review by the governor of the state of Oklahoma before they would even be considered eligible for release from prison. But if the facts of the case were severe, if the person tried to strangle the partner during the altercation, the district attorney has the discretion to then charge that as assault and battery with intent to do bodily harm, or even as attempted murder, both of which remain violent crimes subject to enhancement. All of those safeguards remain in place. The legislature actually classified domestic violence as a violent crime this past year. So domestic violence currently is considered a violent crime in the state of Oklahoma, and that carries with it. That's why anybody convicted of domestic violence, and this is true under 805, would go to prison for 10 years and have the 3 separate reviews before they would even be considered to be released from prison. All of those safeguards remain in place, but the basic domestic violence crime would be 10 years. It would not be enhanced unless it was a violent, like a truly violent situation where the facts supported the evidence that the person was actually intending to do bodily harm to the person that was in the altercation. In that case, under 805, the charge would be filed as a violent charge under the category of assault and battery with intent to do bodily harm up to attempted murder. So those charges carry a punishment of up to life in prison. They're untouched under State Question 805. Those safeguards remain in place. And you have to ask yourself, how did we get to the point where we are literally the number one incarcerator in the nation? The reason we have the highest incarceration rates is because we've made it a practice to send as many people for as long as humanly possible to prison, including for nonviolent offenses. This just sets a standard range of punishment so that individuals convicted of nonviolent offenses are not spending life in prison. That's all it does.
As this stands right now, this would go into effect for any offenses that happen from this point and moving forward. Recently, there was some reforms that applied retroactively for people that were already in the system. Explain how it would work moving forward.
Sure. So State Question 805 does apply retroactively. So it applies to anyone who would receive a sentence enhancement beyond the maximum range of punishment for a nonviolent offense moving forward, and then individuals who are currently serving prison time for a nonviolent offense beyond the maximum range of punishment would be given the opportunity to petition the court for a sentence reduction. So what that means is if the range of punishment is 0 to 10 years for whatever offense the person is serving time for, that's the statutory range of punishment. But because of a previous nonviolent conviction, the person is serving 20 years, they could petition the court to have their sentence reduced to 10 years. So it would only be reduced back to the maximum range of punishment. But they would be given the opportunity to do that. It's not an automatic process. It's a process that they could petition the courts. The court would review their case to make sure that they do not have any violent convictions anywhere in their past, because State Question 805 does not apply to anyone who has ever been convicted of a violent crime, rather people who have only and ever been convicted of a nonviolent offense. If they meet those criteria, then the court of origin would be directed to modify their sentence back to the maximum range of punishment for that offense. This is a modest reform when it's fully implemented, and it'll be over the course of about 8 years. It would result in an overall reduction within our prison population, our overcrowded prison population, of about 8%, an 8% reduction. But that's so necessary when you consider that today our prisons are overcrowded. We are spending over $500 million a year to incarcerate nonviolent offenders. This gives us a chance to take a positive step forward in safely reducing our prison population and making better use of our state's resources.
One of the big problems we've had is there is not enough treatment available for people. So once this goes into effect and they're no longer going to jail, but if there is not enough treatment to take care of those issues, so what is the plan? I mean, if this passes and it's going into effect, what happens then?
Yep. So the only thing that I would say to correct your statement is that people still go to prison under State Question 805. There's not a person who would not go to prison. This does not reclassify. This does not decriminalize anything. So people who are going to prison today will still go to prison. They just won't go to prison for 30, 40, 50 years on a nonviolent conviction. But what it does is State Question 805 saves, when fully implemented, it saves nearly $200 million. But that's about $35 million a year. That's $35 million that can be reinvested, that can be appropriated to enhance and expand and create treatment options so that when people have paid their debt and served their time, we connect them with the help that they need to move forward, to move beyond a mistake, and to become a contributing, productive member of society. So this gives us the resources It's exactly what the state of Georgia and South Carolina and North Carolina and Utah and Texas have done. So as they've safely reduced their prison population, they have reinvested those savings into services that actually address the root cause behind the behavior. And they've seen a tremendous drop in their crime rates, and also a tremendous value in having more people enter the workforce, more employees who are solid, dependable, gifted, talented, determined employees, because they are now productive members of the community. That's what we want to do. State Question 805 gives us an opportunity to transform individuals into tax-paying, productive members of our state. And that's a win-win for everyone.
I want to thank you so much for taking the time to explain this today. So we appreciate that you've taken the time to spend with us to give that more in-depth explanation. It's very helpful.
You betcha, Jill. It's always good to see you. Thank you so much
Sure.
for this opportunity.